just like to speak into the microphones. Don't have to stand. They can just stay seated and be part of the debate. So, item number 3 is the appointment of Deputy Mayor. And I'm proposing to move a resolution that confirms the appointment of Mr. Keith Crate to the position of Deputy Mayor. Keith has been part of this district for many years. He has a huge respect for life here. He's a top polling councillor. He has huge support in the community and will do a fantastic job. I believe he has all the support of the councillors, and I'll be proud to have him as my deputy, and believe he will be a very loyal, supportive and constructive deputy. So with that, I'd like to move that Keith Crate to be appointed as Deputy Mayor of the district.
It gave me great pleasure to second that resolution. Thank you.
Councillor Park. So it's been moved by myself and seconded by Councillor Park. All those in favour, please say aye.
Aye.
Those against? Carried. Thank you. Congratulations.
Your Worship, can I use that term now? Last time I used it, you didn't have that chain on. So first, Your Worship, thank you for having your confidence in me. I use all those words that you use. I feel humble, proud, privileged to take on this position, and I thank my fellow councillors for supporting me. And I promise, like you do, to do my best for the community and get a future for this community that we truly deserve. Thank you all for that confidence in me. Thank you.
Okay, item number 4, standing orders. Rob Goldstreet, Council Solicitor, will walk us through this one.
Thank you, Your Worship. And councillors, this part of the process, to some extent, is known in the game as reading the Riot Act. So the first, it's the one where the lawyer comes and talks to you. So the first step is obviously the council needs to have a set of standing orders. You'll all have watched previous councils. You'll no doubt have listened to and watched Parliament. Parliament has a set of standing orders that controls the debate that you have, and councils have to have the same thing. Standards New Zealand puts out a model set of standing orders, and most councils adopt them with the odd change here and there. The previous council had adopted the standard set of standing orders with a couple of amendments, and what we're proposing to you today is to just adopt those again. But there's a change that has been enacted by the recent changes to the Local Government Act, particularly in the area of giving the Mayor, Your Worship, certain direct powers. Normally what would happen is that the standards, New Zealand standards, would have updated the model standing orders, but they haven't managed to do that yet. So councils around the country we've cribbed on each other, and we put forward a set of proposals that incorporate His Worship's special powers into the standing orders, and they're listed there. We anticipate that New Zealand Standards will produce some amendments themselves in due course, and at that stage we'd anticipate bringing the standing orders back to you for a further review. So I won't take you through, unless you want to, take you through the precise details of it, unless people have questions.
Thank you, Rob. Any questions, councillors? Councillor Body.
Welcome you, Mayor. I know you'll be leading it as a first-time councillor. I do have some problems with some of the wording in the standing orders, and I take on board what's been said, that eventually we'll have probably a brand new lot of standing orders, but at this stage we don't know when that will be. So there's a couple of areas I'd just like to raise, if that's permission of yourself, Your Worship. go to the order paper that you're discussing on page 2, at the bottom, background, you'll see clause 2.4.3. This is on the agenda paper. There's a couple of areas there where it discusses whether we have an equal council or an odd council, as in numbers. I just raise a question in regards of what has appeared on the order paper clause 2.43, when in fact the indicative document, which is the Taupo District's standing orders as they are at the moment, quotes in regards of a majority of members if the number of members, including vacancies, is odd. What I'm trying to work out is one lot is saying that if you have a quorum of 7 persons, a quorum of a committee is 3, where I believe what's stated in the other document, it actually states it would be more than. So I just need some clarification on that.
Through you, Your Worship, the model standing orders, as Councillor Body has pointed out, have essentially, if you've got an even number, you go up one up a half instead of down a half. The previous council, as we've referred to, had voted to change that to going down a half instead of up a half. And obviously this council today can decide whether to retain what the previous council had resolved or to revert back to the model.
The question then would be, if the previous council passed this, would that not be on this document in regards to our standing orders as they exist today?
I think so. You're referring to the draft that the separate document, the draft.
That's on page 12.
This was printed out from the, if you like, the printout. From the standard document, if you like. Those amendments had been attached on by stick-in, if you like. So they didn't show up on this document when it was printed.
They should be in here.
They should be in there, but they didn't come out on the printed didn't come up on the printed document.
Okay, so how do we get through that one, Rob?
Well, Your Worship, the resolution, if the council wishes to retain 2.4.3 as the previous councils had, we just need to amend the resolution to include that number 1 at the top of background. If the council wishes to revert back to the model, then that doesn't need to go in.
I suppose asking here today, is the council happy to continue on with what the previous council have?
That's the question for the council.
So will we be moving a amended resolution here today then?
Well, Your Worship, it depends whether if the council wishes to carry on with the way the previous council had it, then yes, there'd be an amendment to the resolution to add that in.
What are we adding in?
We're adding in what the previous resolution was moved by council. It's been missed out of standing orders, as I see it. So it needs to be added to this. So if you have someone got a suggested amendment to the resolution.
So, Your Worship, if that was to take place, the words that are under in the heading background to the paper, the words under number 1, and the same applies to the words under number 2. Those are both what the previous council had, but aren't part of the model. And so it would be simple to amend the resolution to add those changes in as well.
Okay, so I suggest a new number 3 then.
It would actually be a 7, a 1, a 1 7,
1 7. Okay.
and 1 8. I'm accounting my Romans correctly.
Yeah.
This includes variations previously adopted.
Ah.
The initial.
It is actually in the suggested resolution, is it? Yeah. It's
But
actually,
it just hasn't spelt. It hasn't spelt them out.
If you, Councillor Body, would you like me to put that in? That
Your guidance, sir, we can probably, its decision is whether we accept what a previous council has done, or secondly, we go back to what is in fact on these standing orders, which is my preferred option. Stay where we are.
Okay. So what's the feeling of the council here? Are you happy that the previous council has made the correct decision here? That being the committee quorum of any meeting shall consist of half the members of the number of half the members if the number is even, or one lesser number of members if the number is odd. For example, a quorum of 7-person committee is 3. So it's sort of very semantic here that we need to just, previous council has made that decision. Previous councillors here that were on the previous triennium, was there any issues with those decisions? Okay. Happy. I think I'd like to move, but I'm happy to put that in the resolution just to clarify that for Councillor Body, that committee is as it is at the moment. Bearing in mind there is a new standing orders coming out.
Your Worship, just to clarify, as I understand it, the way that's worded, that only applies to that difference in majority only applies to committees. It talks about committees as opposed to the council as a whole.
Your Honour, what then is the council's position? The adoption of what was passed last.
That appears to be the general flavour here.
Yeah.
Bearing in mind that there is a new set of standing orders coming.
I can say, Your Worship, if we adopt the previous standing orders until the new document takes effect, surely that would be the correct procedure.
So we need to keep the business going. So you haven't got standing orders, you can't have any meetings. So it's been. I'd like to move it with. With amendments,
I'll second that, Your Worship.
Councillor Crate. All those in favour, please say aye.
Aye.
Your Worship, can there be discussion on the motion?
If you want discussion on the motion, that's fine. It's been moved and seconded.
One of the reasons, Your Honour, that I raise these points that we're at a stage where we need, if you like, the Bible, which is your standing orders. There are some, I believe, discrepancies in it, and there is no indication yet when those new standing orders are going to be before us. Some of the various points that we're attempting to raise now may well be in them. So I'm not quite sure, sir.
I must admit, I do agree with you, Councillor Body, that central government, you would have thought they knew the time of getting these standing orders out. They knew they set the date quite a considerable time ago. Thought they would have done it by now. But I appreciate where you're coming from. Okay. Any other comments? It's been moved and seconded. All those in favour, please say aye. Those against? Okay, would you like that recorded, Councillor Body? Certainly. Okay, item number 5. Is that you again, Rob?
Sorry, David.
Yes.
Sir, I just had one. It's just a clarification rather than looking at anything else. On the resolution for item number 4, we talk about on the first point, I just need to clarify whether we're talking about 3.12.1, which is as per the resolution, or in the reading notes it refers to the clause 3.14.1. Can we just clarify which one we're talking about, because they're two separate items? I just wondered if that was an error.
Sorry,
In the reading document, it talks about the council making some changes to the standing order and refers to clause 3.14.1 4.1, but in the resolutions that we're passing, it refers to the clause 3.12. I suspect it's just a typo, but I just wanted to be on it
I
in
think
terms
Councillor
of...
John, it is a typo, confirmed by Tina. It should be 14.
Yes, it's a typo. It should be
Typo.
14.
Okay. All right.
Sure.
Thanks. Item number 5. This year again.
It is, Your Worship, one of the requirements of the first, that the Local Government Act has in respect to the first meeting of the council after an election is that the members must be made aware of certain pieces of legislation. And so the report talks through those, and I'll only touch on them briefly, and then answer questions if there are any. So this is really just for your information. It's a formal requirement of this meeting. Obviously, the Bible is the Local Government Act 2002. I won't confuse you with the confusion that the Local Government Act 1974 still applies in some parts, and you'll have to talk about that at some stages. But your guiding document is the Local Government Act 2002, and as we've set out there, that sets out, Section 10 sets out the purpose. That's why we're all here. And as we all know, the purpose of local government has changed in the last 12 or 18 months. So as a new council, you'll have a slightly different focus than everybody else. But that's your touchstone. Section 10 is what you need to go back to whenever you make decisions. And obviously what officers will try and do is bring reports to you that focus on those issues. What that also goes on to say about the Local Government Act is the role of councillors. Your role is essentially what is commonly known as governance. You make the big policy decisions. The Chief Executive puts them in place. And the paper lists a number of things that we do. The second big piece of legislation that you deal with is what's commonly called LGOIMA, Local Government Official Information and Meetings Act. I don't think the legislative draft is particularly picky about the way they named acts, because this covers two bits. One, it governs your meetings. Now, it doesn't govern the way you run your meetings, because that's standing orders. It governs the way you call meetings. The council calls meetings and how that interacts with the public. But the second one, which many of you will be familiar with, is it's the local government version of what central government has, the Official Information Act. And some people even will refer to it as the Official Information Act, even though that one only applies to central government. And its main principle is that public authorities operate in public. And most information that the council has, that you receive, will be public information that people can apply for. There are some exceptions to that rule, and they are listed in the Act, and they mainly deal with what everybody would understand as being sensible. If the council's doing a $3 million deal to sell some land, you can understand that it's not a good idea to say we're going to offer 2.9 million to that person. To say that in public, because then they'll know what your strategy is. So they're reasonably sensible, but they can be somewhat controversial. And the Local Government Official Information and Meetings Act, LGOIMA, sets out a process where information can be sought by people. It goes through an internal process and ultimately gets ruled on by the Ombudsman. But I think from a council law point of view, what you need to remember is that the general rule is that everything you do is and should be done in public. Next one, Local Authority Members' Interests Act. This is one that can end up with a councillor not being a councillor anymore. So the first rule is about pecuniary interest, and there's two aspects of that. One is if you or somebody associated with you has a contract with the council that involves more than $25,000 in any 1 year, prima facie you can't be involved in that contract. However, the system recognises that that is not uncommon, and the Office of the Auditor General has the ability to grant exemptions, and they routinely do. So it's not something to be concerned about if it did happen that an organisation that any councillor was associated with ended up bidding for a contract or getting a contract with the council. There are processes to have that approved by Wellington, but it is something you need to keep an eye on. An example of how far it reaches when in Whanganui, for instance, a councillor was married to a person who was retired from the family contracting business, but still had one share in the family contracting company. That person was caught by this, that councillor was caught by this legislation. So you just need to think about that if anybody associated with you might be contracting with the council. The next level of pecuniary interest isn't contracting with the council. It's you might be affected in a particular way by a decision. You might be better or worse off by a decision. Now, at one end of the scale, simply being a ratepayer doesn't mean you can't vote on the rates, because the rates will affect you in your pocket. But it does mean if your fellow councillors are voting or discussing the purchase of the house next door to you, or the council's going to buy the house next door to you, or put a Vodafone tower out in front of your property, you might need to think that you've got that might affect your house value, therefore you've got a pecuniary interest. Now, it's wonderful for lawyers because the lines are as blurred as they can be. It's as long as a piece of string. But the advice that we give you is just keep an eye on it. You'll be getting a booklet and some more training on it, guidance from the Office of the Auditor General. Just think about it when things are happening, and if in doubt, seek advice. Your own personal lawyers, for instance, should be able to help you along the line, and you can talk to the Chief Executive, although he and I can't give you advice about it, but we can potentially point you in a direction. The last one there is non-pecuniary interest, and that's what's commonly known as bias. So, as a law student, when English law applied to everybody, they talked about the test being of the common man was the man on the Clapham omnibus, the man on the bus in from Acacia Bay. What would he think? She think about a decision? Could they think that you might have already decided what was going on, or you might be influenced by some external force? Now, the only way that gets tested ultimately is if somebody takes a judicial review of the council's decision. But again, that one's something you need to think about, but is again very difficult sometimes to draw the line. But feel free to ask. These next ones are the Real Riot Act, Crimes Act. You can commit a crime and go to jail, which will naturally or potentially lead to you no longer being a councillor. Those things are really about bribery and corruption, accepting gifts for the purposes of making decisions, taking a backhander. The Secret Commissions Act 1910 is really much the same thing. It's involved in somebody giving you a reward to vote in a certain way. And it also involves, if you like, insider trading, using information you know to tell your mates to make a killing. The Securities Act and Security Markets Act apply to the council when the council borrows money. Theoretically, if we put out directly put out a prospectus, those rules apply exactly to us as they do to South Canterbury Finance or anybody else raising money. As this paper says, generally councils don't do that. This council doesn't, so that one's unlikely to land on you. And the last one is the Protected Disclosures Act, whistleblower legislation. There's a process for whistleblowing, which means that an employee of the council can go through a process where they believe something bad is happening. Same thing applies to the councillors. And essentially what the whistleblower legislation says, you can't be disciplined for properly raising an issue. The last bit of the Riot Act is that generally nobody can extract money out of your pockets for bad decisions of the council. The CEO can go to jail, but you guys generally are protected. In fact, the CEO is generally protected if proper decisions are made. There is a power for the Attorney General to dip his hands directly into individual councillors' pockets if the council unlawfully makes some decisions. Now, unlawfully in that context doesn't mean that a judicial review says that the council should have processed something differently. What it means is that the council deliberately, unlawfully does something. They know the answer's A, but do B, and there is consequently a loss of money to the council. And as you see, if you vote against that unlawful resolution, you're off the hook, for instance. I have to say that I do not know of any instance in the last 100 years that councils have had this surcharge imposed on them. It's not common that happens. I think there was a situation in 18 something or other, or the early 1900s, where it did happen, but it's not it's a big risk if it happens. Obviously, council suffers $1 million loss. You might have that money taken directly out of your pockets, but it's not realistically a risk. And of course, if you go back to the touchstone and follow the Local Government Act, you're not likely to run into that problem. Your Worship, having read the Riot Act,
Rob, consider yourself all told.
I'm happy to take questions.
Yeah. Any questions for Mr. Goldsberry? Councillor Body.
In the start of the document, there's mention of of our code of conduct. Now, I believe that the Act says somewhere that it can take 6 months, is it not, when a new councillor comes in for a code of conduct to be produced. Similar to what we've just had on that vote before, I believe as a council we can alter standing orders to suit what we want. Are we bound by this code until another one comes out and we sign it? Where do we stand?
As I understand it, the code of conduct carries on for that period until you change it.
Your Honour, the reason I raise it, the code of conduct that we're under then at the moment also contains section 10, which is being altered in the new Act. So are we abided by, are we subject to what's in here or that new section 10?
Your Worship, perhaps I can answer that this way. Obviously, the old Section 10's gone, so it doesn't apply to the council. What the Code of Conduct is about is relationships between councillors. It can only apply to, use the generic term, bad behaviour, councillor to councillor, as opposed to anything else. So, while the reference to the old Section 10 is wrong, the new Section 10 applies. The rest of the code, which defines what happens if somebody believes another councillor is behaving badly, will still serve you well in the meantime. It is obviously something that, as officers, we will want to get something up to you as quickly as possible.
Thanks, Rob. Okay, any other questions? Okay, suggested resolution there that the report, legislative advice to the incoming council be received. Moved by Councillor Hickling, seconded by Councillor Park. All those in favour, please say aye. Aye. Those against? Carried. Thank you. Item number 6, just the next meeting, the first meeting as such. Pretty simple there. The first meeting will take place on the November the 12th at 1 p.m. Could I have a mover? Any questions about that?
Your Worship, can I just, excuse me, can I just raise some issues about meetings, please?
Yes.
I was going to raise it under standing orders, but because this item's on here, my concern is that we've only got 3 council meetings. I know we've got training sessions, but actual council meetings up until the 9th of December, 12th of December or something. That's only 3 council meetings in this year. Our next meetings will be right through February. There was items raised in the community during the elections that I think needs to be addressed, at least perhaps one of those items. And we all know what those items were: CV and land value, the bus depot on Tongariro Street, and the car park at 2 Ferry Tower Street. I'm not saying as these items can be dealt with, but I do think that the items need to be on a very early agenda, at least one of those items, to at least start the debate. And my concern is that the meetings, we've only got those 2 or 3 meetings before the new year. So could I have some assurance that 1 or 2 or 3 of those items will be on the agenda either later in November or December, or there'll be workshops on them, Your Worship?
Certainly. Thank you, Councillor Hickling. I certainly have met with all the senior managers pertaining to those issues, and they will be dealt with as quickly as possible. We will workshop them first, so people have a full understanding of all those issues, the implications and complications with them. And it is a matter of urgency, but I would suggest possibly it won't be till February, March, but they do. It is a priority, and I've certainly stressed that with them. Possible there could be workshops on some of those issues prior to Christmas, but probably the actual matters will be dealt with February, March next year. Am I correct, Mr. CEO?
Yes, that's correct, sir. I think it's fair to say that some of the issues, or one of the issues in particular, would be more of a long-term plan type of issue, but we do need to get it out there and start talking about the issue. So it has been raised, and we are preparing information for workshops as we speak.
I would sincerely hope that we could have some workshops before February, March, Your Worship.
The issues were, as you say, very topical, and let's get in and deal to them. Yep. Councillor Oddie.
Your Worship, I support what Councillor Hickling is saying. In fact, if we continue with our debate on standing orders, was an issue that I was going to raise. Can you explain to me, please, the procedure for a workshop? Do we have to have a meeting that then says we will have a workshop, or does someone just decide there will be a workshop? The meeting on the 12th of next month in documentation described as a council meeting, but the advertisement in the paper said it was an extraordinary meeting, and I'm trying to work out if there's a difference between the two. But can you just take us through what needs to be done for a workshop on a particular issue? Because the points that Councillor Hickling raised are very, very valid at this time.
I presume the extraordinary meeting is because there'll be two.
The extraordinary meeting was because we had advertised for a modified time frame, so we only advertised in the prior time frame. That's called an extraordinary meeting. So that's why that's.
It's an extraordinary ordinary meeting.
Okay, and workshops will take place as they're required for further information to receive them prior to the meeting. And
It has to go through a council meeting to decide to have a workshop.
Yeah, I mean, there's two parts to that process. If councillors decide that there needs to be a workshop on a particular issue, generally speaking, that would be at a council meeting, because at each council meeting we look at the following month's meetings and any workshops that go around those, and the councillors can decide at that particular time, let's add in a workshop about a particular topic. So that's one way of advancing a workshop. Another way of advancing a workshop is if there is a particular issue that needs to be workshopped by councillors in advance of a meeting, then the staff will call for a workshop, and that will then be approved by the councillors to get that information to councillors. So the staff can promote a workshop, but also the councillors can promote a workshop.
Any other questions? Okay, suggested resolution there that the first meeting Taupo District Council to be held 1 p.m. Tuesday the 12th of November 2013. Could I have a mover? Councillor Truman moved, seconded Councillor Boddy. All those in favour, please say aye. Aye. Those against? Carried. Okay, quickly, so I realise a cup of tea coming up, but just to finish off, I'd just like to wish all the thank you to the public and friends and relations and cousins and aunties all coming today, and mother-in-laws and what have you. So very nice to see you all here. We have a cup of tea and refreshments. I'd just like to wish all my fellow councillors, well, and congratulations again. This council will be one that I hope works together for the district. And please remember to be courteous to each other at all times and respect each other. Remember, if you want things to change, you've got to get some people alongside you. You've got to get people to like you first, So just remember that, and things will change. You must get the support of your fellow councillors. Good luck, and let's go for it. Cup of tea time. Thank you.